3. Consideration. As per Section 2, Clause D of Indian Contract Act 1872, when, at the desire of promisor, promisee, or any other person has done or abstained from doing, or does, or abstains from doing, or promises to do, or abstain from doing something, such act or abstinence or promise is called consideration for the promise. Consideration means something in exchange of something. That means something in return. Quid pro quo. Note: agreements made without consideration are nudum pactum, a bare promise, and hence void. Rules for valid consideration. First, consideration must be moved at the desire of promisor. Consideration must be moved from promisee or any other person only at the desire of promisor. If it is done at the desire of person other than promisor or voluntarily, it is not a valid consideration. Second, consideration must be moved either from the promisee or any other person. It is immaterial who has furnished it. That means a consideration may move from a stranger to the contract. Hence, we can say that there may be a stranger to the consideration. Third, consideration may be past, present, or future. The words has done or abstain from doing, does or abstains from doing, or promises to do or abstain from doing something are used, which implies that consideration may be past, present, or future. Fourth, need not to be adequate. Consideration may or may not be adequate and need not to be equal value for which it is exchanged, but definitely it should be something which law would regard that it has some value. Fifth, consideration must be real. A consideration must be real and of some value in the eyes of law. A consideration is not real in case when it is physically impossible or illusory. Sixth, consideration may be an act, abstinence, or forbearance. A consideration may be an act of doing anything or abstain from doing anything. Seventh, must not be unlawful, immoral, or opposed to public policy. As per Section 23 of the Act, every agreement, the objective or consideration of which is unlawful, is void. Eighth, a promise to pay one for what he is legally bound to do is not a good consideration. If a person perform any task which was his duty to perform, cannot demand for the consideration for the same. Ninth, according to Section 25 of the Act, an agreement made without consideration is void. In general, it is said that no consideration, no contract. However, there are certain situations when an agreement, even without consideration, is enforceable as explained in the following exceptions. A. Agreement made out of natural love and affection. As per Section 25, subsection 1 of the Act, an agreement made without consideration is valid if it fulfills the following conditions. First, it is expressed in writing. Second, registered under the law for the time being in force for the registration of document. And third, is made out of natural love and affection between the parties standing in near relation to each other. Note: all nearness of relationship does not necessarily imply that there is love between them. B. Compensation for past voluntary services. As per Section 25, subsection 2 of the Act, an agreement made without consideration is void unless it is a promise to compensate wholly or partly to a person who has already voluntarily done something for the promiser. Following conditions should be fulfilled to make the agreement valid. First, voluntary service which is rendered to the promiser. Second, promiser must be in existence at the time of the service. Third, promiser must have intended to compensate the promisee. C. Time barred debt. As per Section 25, subsection 3 of the Act, A promise made by a debtor to pay a time-barred debt wholly or in part is enforceable if it is made in writing and signed by the debtor or his agent, generally or specially authorized on that behalf. Time-barred debt is time-barred by limitation if it remains unpaid or unclaimed for a period of 3 years as per Limitation Act. D. Agency. According to Section 185 of the Act, no consideration is necessary to create an agency. E. Completed gift. F. Charity or donations. G. Gracious bailment. Stranger to the contract. It is a general rule that a person who is not a party to the contract cannot sue and cannot be sued. This is known as doctrine of privity of contract. It is the fundamental principle of contract that only the parties to the contract have right and obligations arising under the contract. A person who is not a party to a contract cannot therefore may enjoy the rights or bear the burden of any liability or obligations. Exceptions. However, there are certain exceptions to the above rule which are mentioned as under A. Trust. The beneficiary in a trust can enforce his right under the trust though he is not a party to the contract between the settlor and the trustee. B. Family settlement. In case of family settlement, the members of the family who are originally not the parties to the settlement may enforce the settlement. C. Marriage settlement. In case of certain marriage contract, a female member can enforce a provision for marriage expenses made in the partition of the HUF. D. Assignment of contract. In case of assignment of a contract, when the benefit under the contract has been assigned, the assignee can sue and can be sued. E. Covenants running with the land. In case of covenant running with the land, a person who purchases the land with notice that the owner of the land is bound with certain duties, the covenant may be enforced by receiver of the seller. F. Contract through agent. A contract entered into by the agent can be enforced by the principal if the agent has acted with the scope of his authority and in the name of the principal. G. Estoppel. When a promisor constitutes himself as an agent of third party by his conduct, a binding obligation is thereby incurred by him towards the third party.